Could Kouri Richins be set free, both now and for good? We got to talk about the defense's new bombshell allegation claiming that prosecutors failed to not only turn over evidence, but evidence that allegedly clears her of the murder of her husband, Eric. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Is Kouri Richins about to get a major win? That is quite a statement. It is quite a statement since we always talk about the mounting evidence against her, against this wife accused of poisoning her husband. Well, it may all center around a key witness. Okay, let me explain. So Richins is accused of murdering her husband, Eric Richins, back in March of 2022. That she spiked his drink, a Moscow Mule, with fentanyl the night of his death. And when I say that there is mounting evidence, what do I mean? So she allegedly told authorities that she found her husband unresponsive at the foot of the bed when she woke up at 3 a.m. But Eric apparently had 5 times the lethal dose of fentanyl in his system. That's according to authorities. That when authorities looked at her phones, they allegedly found searches for women Utah prison, can cops uncover deleted messages iPhone? If someone is poisoned, what does it go down on the death certificate as? How long does life insurance companies take to pay? What is a lethal dose of fentanyl? That she allegedly tried to poison Eric's sandwich the month before on Valentine's Day. He apparently got so sick that he broke out in hives, that Eric allegedly told a friend, "I think my wife tried to poison me." That behind Eric's back, she took out a $250,000 home equity line of credit, that she may have forged his signature, that she was in debt while Eric was worth millions. And talking money, that she is accused of opening life insurance policies on her husband without his knowledge to the tune of $2 million. And of course, if you're familiar with this case, you will know that she is the woman who published a book called Are You With Me? After Eric's death that she said could help kids cope with loss. And she even went on local media talking about it. And now she's accused of murdering Eric. So yeah, all of that is not great. That's a sampling of the evidence that prosecutors seem to have against her. And she is facing multiple counts, including murder, financial crimes. But there is one other key piece of evidence, that may tie all of this together. And the update I want to talk about right now is whether it jeopardizes the whole case. Because here's the question. Where would Kouri Richins have gotten the drugs from? Right? Where would she have gotten the fentanyl? Well, prosecutors say she got those pills from her housekeeper, Carmen Lauber, who apparently spoke with investigators about this. According to a search warrant affidavit, quote, Lauber admitted to supplying Kouri Richins with 15 to 30 fentanyl pills on 2 separate occasions, approximately 1 month before Eric's death. She stated Kouri paid her approximately $900 each time she supplied the pills. She provided details of the solicitation of the drugs, the pickup and drop-off locations, and other pertinent details that have been corroborated with digital forensic evidence. So, slam dunk, right? All well and good for the prosecution? Not quite. No. Here's the problem. Richins' defense team, they are now arguing that, wait a second, Lauber allegedly says she got the pills from a guy named Robert Crozier, but he denies doing this. That he sold Lauber OxyContin, not fentanyl. That the only reason Lauber thinks she gave fentanyl to Richins is because that's what she thinks she was given by Crozier. This is a big development. So Crozier allegedly recanted his previous statement. So according to NBC, he allegedly had said back in 2023 that he sold Lauber fentanyl. And when asked, now, why did you change your story? Crozier allegedly said he doesn't remember what he said back in the day, that he was in the middle of detoxing and he was, quote, out of it. He now claims he's sober. According to his affidavit, Crozier says, on May 4th, 2023, I had been in jail for a short time and was detoxing from drug use. I do not have any personal recollection of the details of that interview, although I have since been told that I agreed that I had sold fentanyl to Carmen Lauber in 2022 on 2 occasions. According to Crozier's affidavits, he told who he thought were prosecutors in a meeting in April of 2025 that this wasn't true. Quote, Mr. Bloodworth and the other individual asked me if I had sold fentanyl to Carmen Lauber. I told them no. I sold OxyContin to Carmen Lauber on 2 occasions in early 2022. I told them that I met her at the Maverick and Draper both times to sell her the pills. I told them that I was certain that I had sold Carmen Lauber OxyContin 30 milligram pills, otherwise known as Roxy's or Roxy 30s. They asked me several times if I was sure, and I told them yes. I was sure I sold her OxyContin. So in other words, defense attorneys are arguing that not only did prosecutors interview him in April, that they learned all of this, but maybe most importantly, they didn't tell the defense. That is the allegation. The defense filing states the prosecution has been aware of this exculpatory evidence since April of this year, meaning evidence to show that the defendant is not guilty. The prosecution did not inform the defense of this information. No press release was issued, no reports, nothing. The prosecution just kept quiet. Let me say this real quick. Even if you're not a journalist, okay, staying on top of what's going on in this world is so important. But I will tell you, these days, with all the media bias, the mistrust, it can feel nearly impossible to know what to actually believe, right? Well, that is why I want to introduce you to our sponsor, Straight Arrow News. So Straight Arrow News is a personalized news platform that empowers readers with unbiased, fact-based journalism, reporting that informs, educates, and actually builds trust from across the political spectrum. So how does it work? So its media mist tool opens readers' eyes to reporting that is not seen in biased mainstream outlets, providing useful commentary and analysis and source transparency along the way so that readers can see what's really happening versus what's just sensational spin. But the difference between Straight Arrow News and other platforms is that their site and app declares the biases of their sources. Their media landscape tool groups and displays outlets according to their leanings to deliver maximum transparency. So if you're ready for a better way to get the news, then go to san.com/sidebar or just click the link in my description. Straight Arrow News. You can skip the drama, get the facts. Welcome back to trustworthy journalism. And the defense claims that the only reason they found out about all of this is because they interviewed Crozier last month. And here's the big idea as laid out by the defense in court documents. Here, the prosecution failed to disclose evidence that not only negates Miss Richins' guilt, but completely eviscerates the prosecution's own theory that Miss Richins procured the fentanyl that ultimately killed her husband. The prosecution's failure to disclose and continued concealment of exculpatory evidence that Miss Richins did not procure fentanyl and inflicted ongoing harm on Miss Richins, the public, and the integrity of our legal system. This is precisely the type of misconduct Rule 3.8 was designed to prevent. By withholding this evidence, the prosecution abandons its duty to seek justice and undermines the assurance of a fair trial. The defense goes on to say, quote, if the state cannot place fentanyl in the hands of the defendant, the state has no case. Mr. Crozier's statement doesn't just poke holes in their case, it throws a grenade into the middle of it, leaving them nothing but speculation and conjecture, getting them nowhere near the realm of beyond a reasonable doubt. Now, in one filing, they're asking the court to issue an order for the prosecution to deliver to the defense all evidence like texts, emails, recordings of any correspondence between the prosecution, the police, and Crozier, any notes discussing him, anything that negates Richins' guilt. But you also have to imagine, is this such an alleged egregious violation of the rules? Could the judge throw out the case? I'll talk about that. By the way, they also make a motion for the judge to reconsider bail, which has been denied in this case multiple times. We're going to talk about that too. So what exactly is going on here, right? Well, let me bring on an expert. We are joined by Jeremy Deus, criminal defense attorney, former Salt Lake County Assistant District Attorney, ADA. Thank you so much for coming on, Jeremy. It's really good to see you. Let me just start here. What do you make of the fact that Crozier apparently has this change in his position, a change in his account? Can we start right there?
Sure. I mean, it's not entirely common for stories to change, but to change this substantially, I mean, it's for this case, it's a pretty big deal, I think.
Yeah, such a big deal that, let me start here, even before the allegation that the prosecution, hid exculpatory evidence. If this is true, okay, and he supplied only oxy and not fentanyl, is that the end of the case? I mean, can they prove that Kouri Richins killed her husband?
I don't know if it's necessarily the end of the case, because there are different things within the rules of evidence that allow the prosecutor to bring in prior inconsistent statements, right? But at the same time, it doesn't help. And I think as a prosecutor, I would view it as a serious blow to the case as a whole.
Yeah, because if Carmen Lauber says, I don't really know what I was given, I assumed it was fentanyl. He's saying, no, I gave oxy. The toxicology reports indicates that Eric had 5 times the lethal dose of fentanyl in his system, and they can't directly tie where Kouri Richins got it from. I wonder, first of all, how do prosecutors change their case? Do they still call him to the stand? Do they still call Carmen Lauber to the stand? Do they forget about where she got the fentanyl pills from, allegedly? How does this change the whole prosecution's case?
But remember, you still have the fact that, according to Carmen, Kouri asked Carmen to get her fentanyl, right? So as a defense, you still have that to deal with. And as a prosecutor, you still have that kind of in your pocket. Why is Kouri asking for fentanyl in general? So, even though this delivery system that they've alleged, this Carmen to Robert, back to Carmen, and then back to Kouri, that whole thing, that may have fallen apart. What the state certainly doesn't have is any sort of new, bridge to the fentanyl. But there's still the fact that, according to Carmen, Kouri was asking for fentanyl. So you still have that to deal with. And it's depending on what side you're on, you have arguments to make.
But by the way, we're also making this argument assuming he's telling the truth now, right? Is he the most credible witness? He may have actually given fentanyl. We don't know.
So there are a lot of things that you look at when you're weighing credibility, right? And what is one of the things you look at is, what is the motive here? What's the motive to lie? What's the motive to change the story? And that's going to be something that's going to be hard to kind of argue against as a prosecutor here. Certainly, like I said, another feather in the cap for the defensive team.
Did the prosecution violate the rules regarding turning over material to the defense, turning over material that is potentially exculpatory, material that negates a defendant's guilt? What is the standard, and did they violate it?
Man, and that's hard because it's a bit of a gray area. I think that it's certainly poor form. When I was a prosecutor, as you mentioned, I was a prior prosecutor. The hope is that as a prosecutor, you are trying to go above and beyond and kind of be above reproach. So the hope would have been that when they had the conversation with Robert Crozier, that they would have disclosed that conversation with the defense. The fact that the defense is just hearing about that, according to the defense team, in September, from April to September, by my math, that's 5 months, and they haven't disclosed such a big thing. Again, I want to be clear, this is a big deal. The fact that he's saying he was not the person who gave fentanyl, him changing his story, it's a big deal. And that's something that I think should have been disclosed back as soon as possible in April. You would certainly think and hope that a prosecutor on the drive back to the office after meeting in the Starbucks coffee shop would have said, hey, we've got a problem. This is what the witness is telling us now. You may want to have somebody go out and reach out to him and kind of interview him. And one of the things that kind of surprises me here is that the prosecution team didn't themselves send out an investigator to kind of get this new information and somehow get it to the defense team. So I think it is a concern. There is an element of timeliness as far as disclosure. They don't necessarily have to disclose it immediately, but they do have to disclose it timely. So whether or not they're kind of in this little bit of a gray area, it's September, they still haven't disclosed it to the defense team. They're set for trial in February. I'm surprised that it hadn't been disclosed.
Well, that's the point. When the defense comes out and says the only reason we found out about this is because we interviewed him ourselves and found out, what would be the defense for the prosecution? I think this is something that the defense mentioned in their filing, that what's the prosecution going to argue? That it was an oversight? Is that the argument from the prosecutors? Hey, we didn't deliberately withhold evidence. This was an oversight of some way. We were trying to corroborate it, but is it even their responsibility to corroborate it, or is it just to turn it over to the defense immediately? It seems like this was a mistake, this was an oversight, it wasn't intentional. That would be the prosecution's defense here, right?
Well, it would have to be. It would have to be, look, it was just an oversight, but at the same time, that is a big oversight, right? That's some pretty critical evidence when as it relates to this case. I would think that they would have to say it was an oversight. I think it's going to be something along the lines of we were busy, we weren't sure how reliable it was. But I mean, even at that, when it comes down to reliability, that shouldn't necessarily be the prosecutor's decision to make. That's something that should be made after having disclosed it to defense counsel. So I mean,
this is such a big issue that I am curious. Different scenario, but if you remember what happened in the Alec Baldwin case, there was a serious issue about evidence being turned over to the defense where his case was dismissed. I mean, if I'm remembering correctly, I believe that's what happened. Is that something that could happen here? The judge could look at this and say, this is a total travesty. This is an injustice. Kouri Richins' rights were violated. I am dismissing this case. Is that an actual consequence if the prosecution really violated their duty?
I think it's possible. I think it probably has to be more egregious, at least the violation, in order to get to that point. But I mean, it's on the table. I just don't think it's likely.
What could be a punishment for the prosecution?
That's a good question. It's going to be interesting to see. I don't know exactly how the judge would rule or really what's on the table for that.
What about agreeing with the defense? Prosecutors, you got to turn over all this evidence. So not only evidence that would negate Kouri Richins' guilt, which obviously they should be turning over anyway, but every correspondence regarding Crozier, everything regarding him. Do you think the judge will grant that request?
I think he will. It's not a guarantee that he will, but given the circumstances, given the whole high-profile nature of the case, I think he will order that be turned over.
Will that delay this case? I mean, her trial's scheduled for February. Does this now put a wrench in all of this?
It's possible. It depends on, number one, how quickly it takes the prosecutor's office to get the defense team the discovery and what the defense team's able to do with it once they get it. How long does it take them to fully review and fully vet any new information that they get from that disclosure?
By the way, I'll talk about bail in a second. As we're going through this, I'm thinking, if now the prosecution is struggling to prove that she got those pills from Carmen Lauber and Robert Crozier, if they can't establish that, how do they prove the pills were in her possession? I mean, A, does that show a weakness in the investigation? Can they not pinpoint another alternative by which she would have gotten those pills? Because they have to establish, I think, in some way, where did she get them from? Otherwise, that's something the defense is going to jump on in an opening statement, a closing argument during the course of the trial. If they can't establish that, does that show a weakness, a gap in the investigation?
So I don't know if it's enough to necessarily get the case thrown out. Remember, this case has always been circumstantial. The question when it comes to circumstantial cases is how strong is that circumstantial case? It's absolutely weaker with Robert Crozier's disclosures that he never gave fentanyl, but the prosecutor still has the fact, according to Carmen Lauber, that Kouri was asking for fentanyl. So you have Eric overdosing on fentanyl. You have Kouri asking for fentanyl. You still have that to use as evidence. And is your case weaker without that bridge that shows this is where she got the fentanyl from? Yeah, it's weaker. But at the same time, it's still something that the prosecutor's office could still potentially go forward on. But yes, you're right. It is a weaker case because they can't point to the distribution route that it took, that Kouri allegedly took to get the fentanyl.
I want to talk bail here, okay? And I want to talk the defense's motion for the court to reconsider it and for Richins to be released in light of this development, because again, she has been denied bail twice so far. So they cite in their filing how under Utah law, an individual charged with or arrested for a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony when there is substantial evidence to support the charge and the court finds by clear and convincing evidence that the individual would constitute a substantial danger or the individual is likely to flee. Quote, although the court has previously found that there is substantial evidence to support the charges against Ms. Richins, Mr. Crozier's recantation of his previous statement changes the landscape to a degree that cannot be ignored. In order to continue to hold Ms. Richins without bail, the court must first find that there is substantial evidence to support the charge and that simply no longer exists. In this matter, the state's entire theory of criminal liability is that Kouri Richins procured fentanyl from her housekeeper, Carmen Lauber, which she caused to be unwillingly ingested by her husband in some unknown way, directly causing his death. There is no physical evidence of this, but only the statements of Carmen Lauber. And these statements are wholly dependent on whether or not Lauber procured fentanyl from Robert Crozier. None of these so-called fentanyl pills were found nor tested. Lauber only believed she sold Kouri fentanyl because she believed that is what Crozier gave her. If Robert Crozier did not in fact sell fentanyl to Lauber, there can be no credible argument that substantial evidence of guilt exists. And they argue that she should be released. Good argument, Jeremy?
I think so. I really do. Remember that when it comes to Utah's bail statute, it's multi-pronged, right? The first thing that the judge has to find, like you just read, is that there's substantial evidence to support the charges. The prosecutor's office, when they've gone through and they've argued their motion to hold without bail up to this point, they've had this distribution bridge with what Mr. Crozier has come out and said that he never sold fentanyl to Miss Lauber. With that statement, it destroys the distribution bridge. And so it does cut against the substantial evidence nature of the case. And so I think it is ripe for reconsideration. And I do think the defense argument is a good argument, and I think it's sound.
Let me ask you this. Apparently, the Summit County Attorney's Office said, quote, it doesn't comment on pending matters, that it's going to respond in the public record in 14 days as allowed under the court rules. Is that a response you were expecting, and how are they going to respond?
I mean, it's how they have to respond for now. The fact that this has now come to light, it's in the media, they're going to be very, very careful with how they respond, given the high nature of this, given the allegations that are put forth by the defense team. I mean, like we've already talked about it, it is a big deal that the prosecutor's office learned about this kind of recantation, this changing of events of saying that he did not sell Miss Lauber fentanyl, but that he sold her OxyContin. It's a big deal, and it opens the door.
And real quick, big picture, I might be a little repetitive, but if the prosecution can't definitively prove how she got the pills, and they can't definitively prove when or how she allegedly put it into this Moscow Mule, you think they still can get a conviction based on the circumstances of his death, her statements, her behavior, the life insurance policies, her alleged Google searches or searches on her phone? Do you think they could still get a conviction based on everything else they may have?
I think it's a possibility. How likely the possibility, I don't know. That's going to be something that the prosecution team's going to have to evaluate. Remember, you just listed off a whole bunch of evidence. And even though they don't have the foreshore distribution chain, like we've already talked about, they still have the fact that Kouri reached out to Miss Lauber and asked her to get fentanyl. All we know is that the distribution route didn't come through Miss Lauber. That's the only thing that we know. But the prosecutor's office still has everything that you just mentioned as far as being able to sit in front of the jury. They may say, look, we don't necessarily know how she got the fentanyl, but we do know she was asking for it, and we know that he overdosed on it.
Yep, that's a good point. This is an interesting development. We wanted to cover it. We've been focusing on Kouri Richins for quite some time. I think this is significant. Jeremy Deus, thank you so much for taking the time. It was great to see you.
Yep, thank you. Good to see you as well.
And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll see you next time.